right? It's possible that this sort of thing occurs. Now, there's another possible drawback of having a single unitary executive. All right, so Audrey, let me ask you this question. What happens if, let's say, there's a crisis, something very urgent, and you allow the executive to exercise certain powers, right? It's like, okay, you know what? Things are really scary right now. Go ahead, Mr. President, and do the right thing. What's the risk with that kind of approach?
That in the future, if they have that same power, the president could kind of, in his way, make up an emergency or his own.
Or never lets the emergency conclude.
Yes.
Right? You know, I was giving a talk some years ago, and some student asked me, you know, doesn't the president have extra powers during an emergency? And I think I responded to the student, who's to say when the emergency begins and ends? And there are countless examples in world history where you have leaders of nations who come to power during a time of crisis. They exercise authority, and then when the crisis concludes, they don't relinquish that authority. I can give you examples 1,000 deep of that exact scenario. Yeah, Chelsea.
So who would determine what an actual emergency is?
Oh, I mean that's the topic of Merriman, isn't it? But we'll get there in a minute. I'm not quite there yet, right? But I want to finish my rant for a bit. What do you do then when an executive declines to relinquish the authority that he asserted during the emergency? All right, again, impeachment, of course, is always a remedy. But ultimately, I think at least, the character of the individual is of the utmost concern. One of the reasons why George Washington was considered such a figure of high stature, was that he relinquished his authority. At the conclusion of the American Revolution, he resigned his commission. He resigned, he went to Annapolis and laid down his sword. And that was a momentous occasion. He could have said, okay, now I'm the king. I led you to victory, make me the king. He did not. He went back to his farm Mount Vernon, and he retired until he was called again. And then after 2 terms in office, Washington stepped down. He showed us how to say goodbye, as the song goes, and he set an example that lasted for a very long time of stepping down after 2 terms in office. But there's no guarantee you have such a person of character in office. Yeah.
If I was reading it correctly, it almost seemed like the Article 2 was kind of tailored for a President Washington-like figure.
Well, Washington was the unanimous choice for the first president, basically. And they probably thought of having a man like George Washington in office when they were writing the position. But framers also recognized Washington would die eventually. And eventually there'd be someone else who would have to step in. Yeah, Audrey?
In regards to Federalist number 70, what we read, Hamilton, whenever it talks about like the duration of the presidency, and he wanted like a lifetime president.
He did.
But is what you're saying?
Hamilton lost.
Yeah.
Hamilton was, so let's give you a little history. Hamilton thought he would be president one day. And so his discussion of the lifetime thing was basically him.
Okay, yeah, that makes sense.
He had very high hopes, and those dwindled quickly as history goes. But he envisioned himself as becoming the president of the United States for life.
I kind of see that in how he put in there people naturally born or were there at the signing of the.
Well, that wasn't only for Hamilton. There were other immigrants. So the Constitution says to be the president, you have to be either a natural-born citizen or a citizen at the time that the Constitution was ratified, which would. Hamilton was not born in the United States. He was born in the colonies. He was born in the Caribbean, in St. Kitts. But there were other foreigners who would have also benefited from that. But Hamilton would have certainly benefited from it. Very good. Okay. All right, so any questions on the Federalists and what Hamilton's trying to get at there? Okay, let's do the first case, Ex Parte Merryman. It's sort of an outlier. It's not a Supreme Court decision. I think, if I remember correctly, this is the only non-Supreme Court decision you'll read this term. It's a very unique case, and really my thinking on this case changed a lot because of the writings of Professor Tillman, who I referenced in the supplement. But most people get this case wrong. In fact, I think I taught it wrong for 4 or 5 years until I read Seth's article. Let me just give you a little background first, and then we'll dive into it. The lead up, the election of 1860 was a very, difficult time. Whatever people say that our nation now is in this dangerous spot, I'm like, yeah, right. Come on, we've had much worse, right? Whatever we have today pales in comparison to what's going on in the 1860s. Ain't even close, right? States are not opening fire on federal troops. It's just, we are. Things might not be happy, but get some perspective. We've been through worse, much worse. But let's start by talking about what happened in 1860. The election of 1860 resulted in Abraham Lincoln being president. He ran on the new Republican ticket. He did not receive a single Southern electoral vote because Lincoln was viewed as an abolitionist. Now, even though Lincoln personally opposed slavery, he did not favor abolishing slavery in the slave states. In fact, when he took his oath of office in 1861, Roger Taney gave him the oath of office. Lincoln tried to put the states at peace, saying, look, we're not going to take any federal action to disturb slavery. Let's preserve the Union for now. But Lincoln's efforts were not successful. Shortly before the inauguration, a number of southern states seceded, 7 of them. And after the inauguration, Confederate forces fired on Fort Sumter in South Carolina. And this was a momentous occasion. We basically had U.S. citizens opening fire on a military installation. The word treason is usually thrown around pretty lightly these days. This was actual treason, opening war against your own government. Right? This is not like issuing tweets that are just whatever. This was actual treason, right? Again, sense of perspective. If you study history, things like, okay, whatever, we'll be fine. I don't worry that much. I really don't. Things come and go. And then shortly thereafter, a number of other states then seceded, and they asserted that they were forming a new country, what was known as the Confederate States of America. Now, this is an important point. Throughout the entire Civil War, Lincoln never recognized the Confederate States as another country. He didn't. Congress never declared war on the Confederate States. Why? To declare war would be an acknowledgement that, in fact, a new country existed. Right? You can't declare war on your own country. That's not a thing, right? War is a state that exists between 2 nations. For Congress to declare war on the Confederacy would be an acknowledgement that the Confederacy is a separate nation, and they would not do that. Instead, Lincoln asserted that the southern states were in a state of insurrection or rebellion. And you've had rebellions before, right? You have people who are trying to take down their own government. But that raises a problem. If Congress doesn't declare war, where does the president get the power to fight a war? Lincoln relied on a broad assertion of executive power coming from Article 2, the commander-in-chief of the armed forces, right? He shall take care that the laws be faithfully executed. he looked to these sorts of clauses as giving him the power to basically lead a military campaign against the Confederacy, which he never acknowledged was a separate country. There are lots of questions about whether Lincoln was within his own powers to act. We have here Merryman with the habeas corpus. We have the next reading on the Emancipation Proclamation. Lincoln also seized telegraph wires. He seized mail. He seized railroads. He did lots of things that were arguably unconstitutional. And you might say, yay, go Lincoln, go get the Confederates. But the rub about executive power is you love it when it's your guy, right? When you like what the guy's doing, when the president's using executive power to seize railroads to prosecute the war, for example. But when it's not your guy, when you don't like what he's doing, tables turn very quickly. I think it's very important to assess Lincoln's actions not based on whether you agree or disagree with his policies. I think we would all probably agree with his policies. But whether his powers set a precedent that other presidents can then abuse. Right? If there's a principle that helps President A do something, then that same principle helped President B do something else that you may not like. And I'll give you a very concrete example. Lincoln vigorously opposed the Dred Scott decision. And Lincoln argued that Dred Scott was a conflict between Dred Scott and Sanford. The federal government was not a party to the case. Therefore, he argued the federal government was not bound by Dred Scott. Congress could continue recognizing citizenship of freedmen in the territories. You might say, well, that's great. Yeah, screw Tawney, right? Forget Dred Scott. Okay. Following Brown and other decisions involving desegregation, Southern states said, well, we weren't parties to Brown, so we're not bound by it. We're going to keep segregating our schools. Okay. Okay when Lincoln does it, not okay when the Southern states do it after Brown v. Board of Education. I'm not asking your opinion on this issue. All I'm asking is to consider the exercise of executive power separate from the person exercising it as a neutral principle of law, if such a thing can exist. Yeah. You can ask all of your questions. What are you?
So, the reason why, like, as you were speaking, I was just kind of like, is because it just seems like you're saying, okay, like if it's your guy, we can support it, right?
Mm-hmm.
But I mean, honestly, it kind of seems like we're going back on ourselves here. It's like, okay, before it's like we want to limit the Congress's powers and like whatever. We want to limit the executive because it benefits us. Where does it stop? Like, it seems like we criticize one approach because it doesn't benefit us, and now we're doing it again here.
What do you mean benefit?
I guess like in terms of trying to circumvent the executive's power to an extent.
Mm-hmm.
In this case, I feel like it benefits like a more conservative approach, but in a lot of instances, let's say it wouldn't from a progressive perspective.
You talking about Merriman now?
Yeah, just in this context of like how you're saying it. So to me, I feel like I don't follow sometimes because, I guess what I'm trying to say is we always talk about the really behind things.
Mm-hmm.
And when you were explaining this, I felt like it was another example of that. Like you were saying, like to what extent are we going to limit the executive's power, right?
Well, it's not whether I want to limit it. It's whether the Constitution itself imposes that limit. Right? It's not what Josh wants, right?
No, I'm not saying like personally, not what you want, but I mean, the extent just seems to change every time. It doesn't, I don't know, it just seems like whichever way you're interpreting the Constitution, it's going to change each time.
Mm-hmm.
Which seems problematic to an extent. But do you see where I'm coming from? Maybe I'm not explaining it the way I should.
Well, let me try to ask you a follow-up if I can.
Okay.
let's take Merriman, for example, right? It's our first case. We'll get there in a minute. I promise, Tyler, you're on tap, right? We'll get there. And here there's a question of whether the president can suspend habeas corpus or can Congress suspend habeas corpus, right? In this case, Congress didn't do it. Lincoln suspended it by himself, right? Under the broad Lincoln reading of executive power, then he did nothing wrong. As a result, John Merriman was locked up for basically bogus charges, right? And he was held for some time and he was never actually prosecuted because they were bogus charges. Do you think at least this case can be resolved by a principle of law in the Constitution, whether Congress or the president can use habeas corpus?
I suppose you could say in this regard, but
What do you mean suppose? I mean, let's just talk about this for a minute, right? Do you think there's actually a principle of law that a court could use to resolve whether Congress or the president can answer this dispute? Oh, I put that in the book, right? But I'm asking you, do you think that's actually a real thing, or is it just whatever?
no, there is.
So there are some questions that we could resolve based on the Constitution. Yeah. Well, let me ask you differently, right? What if I told you that by this point we had 80 years of presidents sitting in office, and none of them had ever tried to suspend habeas corpus before? Would that do anything for you?
Huh?
Would that do anything for you? Would that help your argument?
So that was the one when I was like writing my brief that I had an issue with, because I feel like in practice it probably makes sense to follow, the experience of the time. But then I feel like it kind of goes against, like, if it's not an enumerated or implied power, then are we just kind of doing whatever we want now? Like,
Well, but maybe if there's an answer that the Constitution is not clear about, maybe one way to understand that is by looking at the practices of people who existed closer to when the document was ratified. That if Washington didn't do it and Jefferson didn't do it, then maybe they had a better sense of it than Lincoln 80 years later.
but aren't we picking and choosing which circumstances we're going to do that for? Like if there's something that's not implied or enumerated in the Constitution, and let's say there's no like experience of like precedent like this, then it's like a loophole.
What do you mean loophole?
I guess like what I'm not buying is like that there aren't times that you can go around this for so many things, and that's why it's difficult for me when you're talking about this to accept it, because I feel like you can always manipulate this in a different way.
Manipulate, okay. So if yeah, so
I'm listening.
no, I want to ask one more question. I'll get you a minute, Sarosh, I promise. So what you're articulating, I think, is not just a criticism of me or this class in general, but it's a criticism of, I think, the law in general, right? And the enterprise of judging, that if judges can manipulate, I'll use your word for a minute, in a given situation, read it this way, one way, that way, then that's a criticism of the entire judicial process, not just of Lincoln or me or this class. It goes for torts or contracts or property or whatever class you want to take. Is that where you're coming from?
Makes more sense,
Yeah,
yeah.
and I think it's an absolutely valid perspective and one that a lot of people hold. You're not the first person to make this argument in class. So I knew where you were headed, so I just wanted to kind of let you get along the way. But it's a perspective that law is merely a reflection of who's in power, and it doesn't really matter what the arguments are. You can make a structural argument here, you can make a historical argument there, and it doesn't really matter.
It's more subjective.
Yeah, I don't hold that perspective, but it's a valid perspective that a lot of people do hold. What I will leave you with, at least in this class, is what I try to teach you is what's known as constitutional doctrine. Even if you disagree that it exists or it's applied consistently, I still think it benefits everyone to know what that doctrine is. For you to be able to say that, in other words, the fact that you said doctrine A was applied here in this way, and doctrine B was applied there in that way, I'm happy with that because you tell me what the doctrine is. right? The ability to actually criticize the court for being inconsistent with its doctrine is a plus in my mind, because you know enough of the law to say that it's not being applied consistently.
So you're saying that, so there is an objective approach.
Oh,
by judges.
I think there is, but maybe I'm naive.
Okay, so then that's what it is. Like, you can view this, the Constitution, the way it's implied, from either constitutional doctrine, which would be an objective approach, versus a subjective approach.
Yeah, look, Vivian, I'm not trying to persuade you that I'm right or that Lincoln's right or that Taney's right. I could care less whether you agree with us. My only job in this class is to teach you what that doctrine is. You can take it from there wherever you want.
No, I just didn't understand if there was like a one, like.
Well,
I didn't understand it was like an approach kind of thing. Like.
I think that the courts, and I mean this sincerely, they do try to follow a single doctrine. Whether they do or not is open to debate. There are some cases where they expressly change it. Think of the legal tender case, right? Where one year they say the paper money is no good, and the next you have a couple new judges and say the paper money is good. Right? Think of the New Deal cases where they thought, oh, direct effect is the right test, and a couple years later, it's no, substantial effects, right? So there are instances where court changes doctrine. But I think all judges, left, right, center, I mean this sincerely, do try to start with the text of the Constitution, and then they sort of go different ways from there. But it's not to say that's illegitimate. They're doing the best they can. I mean, the flip side is, right, let me ask you this question as well. What's a judge to do if they get a case like this, right? You're the Chief Justice, you get this case, Mr. Merriman's locked up. He asks you to help me. What do you say? I'm going to let you go because it's the right thing to do? Or I'm going to let you go because it's not fair you're being locked up? Or I'm going to let you go because Lincoln's being a tyrant? You write an opinion in the language of law, right? You're going to be a lawyer in a couple of years, right? All of you will be. You can't go to court and say, declare this law unconstitutional because I think it's unfair. Right? You're not going to go very far. Yeah. Right? You have to make an argument grounded in this language of law. So even if you don't agree that this language is real, you have to be fluent in it. And that's the way I approach these cases.
No, yeah, thank you. I'm not trying to be difficult. But
You're not at all.
Just like when I understand it from, when I feel like it fluctuates from like not class to class, but like week to week sometimes.
That's fine. That means you're paying attention. No, the fact that you can discern fluctuations means that you're actually paying attention, which is good. Right? I mean, what most law professors try to do is reconcile case A and case B and make it make sense. It's not easy. I can point out the same inconsistencies here. Okay. Sarosh has been patiently waiting. Yes, sir.
Yeah, my whole issue with, and again, we're talking about, concurring with what you said about, it's your guy, you're happy about it. When it's not your guy, you're not happy.
Mm-hmm.
I mean, I think everybody can agree in hindsight that President Lincoln is our guy, but I think he opened a very dangerous precedent. And
How so?
Well, if he's suspending habeas corpus on John Merriman in Baltimore,
Yep.
what stops President Trump, for instance, or a president that comes after President Trump, to say that, well, this person's an enemy combatant? President Obama did that, and with the NDAA, the National
Defense Authorization Act.
Which which comes from the Lincoln Doctrine.
Not directly, but I see your point, right? Bush was relying on a statutory authority, as was Obama, whereas Lincoln was relying on the Constitution. I don't assign the Guantanamo cases. I think they're sort of like a black hole. Like people have just forgotten about Guantanamo Bay. It's there. People are there. Justice Breyer had a dissent last week where he basically said, "Hey, don't forget about Guantanamo," and he was the only one who joined that. No one else. It wasn't even a dissent. It was a statement. But I think Sarosh should make a fair point. If we start from the premise that there are no actual constraints on the president, that it's simply whatever he gets away with, then yeah, then the courts don't have any basis with which to tell the president to stop. Right? I mean, we read all these opinions. I think Merriman's a perfect example of this, where the judge says, Mr. President, you broke the law, therefore you have to stop breaking the law. There's no guarantee that when the court says you have to stop, that the president actually stops. Now, we've had 200 years of history where presidents have not told the courts to get lost, but we studied the first week of class with Marbury. John Marshall recognized implicitly that were he to order Jefferson to issue the commission, he wouldn't have done it. And he didn't do that. In this case, in Merryman, I'm sort of skipping to the end, but Roger Taney did not order Lincoln to release the prisoner. Right? John Merriman stayed locked up. He just basically sent his opinion to be read by the president to no effect. In contrast, look at Truman, right, with the steel seizure case, Youngstown. Supreme Court said in a 6-3 vote, you can't seize the mills. And the president complied. Now that's powerful, right? Why did Truman actually comply? He obviously wasn't persuaded by the court's reasoning. If he was, he wouldn't have done it in the first place. He obviously felt that there was some compelling separation of powers reason why the law should be followed as the court interpreted it. And that's where the law becomes important. The court didn't just say, Truman, you seize the mills, that's bad because we think it's bad. They had an argument grounded in text and structure. So again, even if these arguments are not applied in a consistent fashion, they exist. And they exist in powerful ways to stop presidents from doing stuff. And if you reject the notion that there are these principles, then I think it comes very quickly that the president may also reject those principles exist. Right? If you simply say it's whatever, then the president can say whatever. And if everyone's like whatevs, right? Then you know we're
That's why we get Watergate.
well, I think Watergate's a very different example because Watergate, in fact, the president was almost impeached and removed from office. That wasn't whatevs. There was actually a legal process that was designed to investigate his wrongdoing. All right. Does that make a little bit more sense? Anyone? Yeah. Well, yeah.
Yeah, sorry, that's just what I finished. Yeah, that helped a lot.
Good.
I didn't realize, like, I don't know anything about the Constitution before I took this.
That's
class,
okay.
so
That's why you're here.
I'm trying to put it in context for myself so I can, like.
You're all here for a reason. That's why you're here. You're wasting your Saturday night in the summer. No, I mean, it's 6 o'clock on a summer evening. Okay. All right. Any other questions before we actually get started? All right. Tyler, you want to give me the facts, please, in Merryman, 30 minutes into class?
Yeah, I'll comment real quick.
Please, yeah, of course. If you have a comment, please, by all means.
Couldn't sleep last night. I got thinking about like.
Oh God, am I giving you insomnia?
No, but it's funny how you gentlemen caused this book of showing up in different places now on research or whatever. I was thinking, my first exposure to President Obama was he presented himself as a constitutional law professor.
He was an adjunct.
Yeah, I saw the whole debate, lecture, senior lecturer, what was it, and stuff like that. But there was a conversation about, how did he teach his constitutional law class? And your colleague, Randy Barnett, commented and basically laid out exactly what you just said, is that it wasn't his job to have a platform for progressive policy and only select cases and hearings and facilitate conversation. But he said he taught it and he reviewed the exams that were consistent with most constitutional law cases that allowed students to see two different perspectives on most every issue between the powers of government and then form their own opinions. And I would have thought it would have been different. I would have thought it would have been, his personal views, but it wasn't like that. And that's what's cool. What that says to me is it doesn't matter, what political affiliation or whatever. The formative basis is the same.
Cases are the same,
Yeah.
right? Now, I'll be very clear. If you took, Professor Kelso for ConLaw, or Professor Rhodes for ConLaw, you'd probably have a little different experience than you are sitting in my classroom. But I think at bottom, you'll leave with roughly the same base of knowledge. I mean, I think Rocky and Randy are both very good friends of mine. We get along quite well. Or Dean Treese, we get along quite well. But there are a lot of overlaps, right? The entire thesis of our book is 100 cases everyone should know. I guarantee you that President or Professor Obama, as he was then, taught of our 100 cases, maybe 80 of them, 75 of them, right? We've actually done math. We've actually checked. In most case books, there's a 70 or 80% overlap of our cases to other case books. It's pretty. It's not 100%. It's 80%. This is what I mean by this is Randy's phrase, the language of the law, right?
Yeah.
to be a constitutional lawyer, you have to be fluent in certain cases and certain doctrines and principles, which you can use to your advantage to help your client, right? The same people who tried to get people out of Guantanamo Bay, for example, were using arguments against Lincoln, right? People who were trying to stop President Bush's wiretapping were using arguments against steel seizure cases, right? These sorts of cases generate language which you can then use. I mean, my goodness, the travel ban litigation from last year was based in a large part on the Korematsu decision, which you have for class for, I think, tomorrow. So you need to know these cases. You have to be fluent in them, right? And if you understand these cases, you can then make arguments based on these cases. Anyway, I think, yeah, and I reviewed, it's funny, I once actually did a debate on Obamacare in the Barack Obama classroom at the University of Chicago. They have like a huge portrait of him on the wall, and I'm going to be doing a debate on Obamacare. No, it wasn't Obamacare, it was some sort of executive action he was taking. I can't remember which one, but.
I think SNL did a skit about it too.
Oh, yeah?
Yeah, Rhodes makes fun of Obama during this.
Yeah, from what I understand, he was a very good professor. He got very good evaluations. I looked at his exams. His exams were fair. I thought he, as best I can tell. I know people took his class. He was a good teacher. You know.
So I was curious. Like when this stuff, he didn't teach as much constitutional law as I had been led to believe. But I was curious as when this came across his desk, when Affordable Care came across his desk, what was he defaulting to Commerce Clause? Supremacy
Read my
Clause?
first book.
What's
Yeah,
gonna be?
yeah. I mean, I wrote a book about it. I mean, it's. You know, President Obama made this comment once. I don't say it lightly, but he actually argued that as a constitutional lawyer, he should be entitled to more deference when he makes executive decisions. And the converse of that is when you're not a lawyer, you should be given less deference. But I'm convinced that he understood ConLaw so well, it may have been to his disadvantage, because sometimes when his advisors told him no, he's like, well, I can think of an argument to the contrary. And he knew enough to come up with an argument to the contrary. And he would often push his advisors to, as he said, the boundaries as far as we can go. And the fact that he had so much knowledge allowed him to tell his advisors, no, you're wrong. I can think of a different argument for why I have this power to do this. You know, he wasn't just a president, he was actually an advocate for his own presidential power. Lincoln was a lawyer, right? Lincoln argued before the US Supreme Court, and he understood these arguments implicitly. He wasn't just making crap up. He was actually giving statements based on his reading of the US Constitution. And he took his oath of office seriously. He said, I read my oath of office to give me the power to do X, right? Go look at the Emancipation, right? I see my power to faithfully execute the laws to do the power to do Y, right? Go look at the Merriman, the habeas corpus decision, right? He understood his powers well. Franklin Roosevelt was a lawyer, right? Harry Truman was not a lawyer. But FDR was a lawyer, and he understood it. Even Bill Clinton was an attorney. Bill Clinton taught ConLaw at the University of Arkansas. Funny story. He actually once lost the final exams, which is like the most Bill Clinton thing ever. He lost the exams. He lost them. He didn't know where they went. So I was like, I think you just gave him a credit. Can you imagine if your professor lost your final exams? You'd probably murder him, right? My grades are due tomorrow. Almost done.
So in Merriman, what?
Yeah, let's give me the facts. Right? I'm giving. Okay, we're having too much fun.
So
Too much frivolity.
Lieutenant in the Maryland militia, and there's some thought. I mean, his role in the Baltimore mob, 1861, like a week after the first shot, is he was the guy that was leading a group of people that destructed the Maryland, the Baltimore Telegraph Service, and so based on that act and a few other alleged acts of treason, I guess what was ultimately on his indictment, is he was arrested. And President, deliver the body is
Habeas corpus,
writ of habeas corpus had been suspended. And, as far as precedent, not precedent, I think the Jefferson comment could be construed as precedent. I think the application's different. Aaron Burr was a little bit different than a time of insurrection. But he being the president, deviated from the only precedent, I guess, we had at the time. Now, so the Chief Justice, was he not in his capacity? He made it seem like they showed up at his house, like in his
Yeah, that's exactly what they did.
So
Yeah.
this was not original jurisdiction Supreme Court
No, it was
stuff.
not. Yeah, let me thank you, Tyler. It's very good. Let me just pause and go over the history. This is a bizarre case, and again, if you want to read more in this supplement, I gave a link to Professor Tillman's article, so you can find it. It's online for free. But this is a very bizarre case. Basically, what happened is that Merriman was arrested under the orders of the Union General, George Cadwalader. And he was held at Fort McHenry in Baltimore. If you ever visit Baltimore, it's still there. You can visit it. That day, Merriman's lawyers basically went to Roger Taney's house and they delivered papers asking for writ of habeas corpus. This was not a case decided by the U.S. Supreme Court. It was decided by the Circuit Court for the District of Maryland. Taney was what was called the Circuit Justice, which means he had supervisory authority over certain types of disputes that arose from that court. But the exact context in which he issued this opinion is largely unclear, right? Again, Seth and I, we've talked about this. We can have theories, but it's not entirely clear what Taney was actually doing here, right? It wasn't clear that he even had the authority to issue this opinion. He wasn't the trial judge, right? This wasn't presented to the U.S. Supreme Court in its original jurisdiction, as Tyler mentioned a moment ago. We don't know what this is, right? It's neither fish nor fowl. We don't know what it is, which makes it even more peculiar. I can't say the word peculiar of what was going on, right? There was no discussion of jurisdiction, right? This isn't a case that was litigated. It happened within the span of a couple days. So anyway, so on Sunday, they basically show up at Taney's house, and they say Merriman was locked up, right? So then the next day, Taney issues a writ directing the commander of the fort to produce Merriman's body for hearing on the following day. Right, so it's not clear if there's actually any jurisdiction. But why don't you imagine what happens, right? Taney tells his poor deputy, right, the marshal, to go up to Fort McHenry, knock, knock, knock on the door, and tell the general of the Union Army, please release this prisoner. Who the hell are you, right? I mean, who is this little punk? And I mean, that's, nowadays, courts issue injunctions against the president every 5 seconds. They drop everything, they follow it, right? But here, you have a judge, the Chief Justice of the Supreme Court, sending a message to a military fort that was basically being, in a time of war. Like, this was not like, you visit these forts as like historical sites with gift shops stuff. No, this was an actual functioning military fort where troops were coming and going, prisoners were being locked up, right? There was an actual war going on. You can imagine this poor guy knocking on the freaking door and saying, I got this little order here. I mean, this guy knew he was going to get shot down. And at that point, Taney had to know this was going to be ignored, right? So
It's like he sent,
yeah.
Posse Comitatus. It's like, go get some more people.
Yeah. He's like, we'll put together what's called a posse, basically a group of people to go take down the military fort. I mean, it's insane, right? You're a military guy. There's just this notion that's just is nuts, right?
Yeah.
It's crazy.
It's like my understanding of what that used to be. It's like any randos you can find.
Randos, yeah.
Assist you,
To enforce a judicial writ.
Yeah, it's like probably like maybe 12 people at most.
Yeah, to go take down a Union general fort, right? Okay, so then what happens next? Well, as you probably know, if a court issues an order and you don't obey the order, the court can then hold you in contempt. What is contempt? It's a sort of inherent power of the court. We talk about implied powers, right? It's the power of the court to hold you in contempt, which literally means they can jail you, right? In theory, you can jail a person in contempt until they comply with the court order, right? So basically, Taney tries to hold the general contempt. But the general sends over a deputy who puts a letter. The letter basically says, the President of the United States authorized the suspension of the writ, and therefore, we're allowed to do this. Okay, so then again, Tawney holds the general contempt, and this poor marshal is sent to the fort to arrest the general. Can you imagine? Right, this poor guy is being sent to a fort to arrest the Union general and to drag him from court. Again, it wasn't to bring Merryman. It was to arrest the general for ignoring the court order. Right? At that point, the proceedings were not about Merryman. The proceedings were about the general. Right? That's what the case became about. It's the contempt hearing for the general. Now Tawney talked about the habeas corpus issue. He talked about this, right? But the subsequent proceedings were actually about the general, Cadwallader, and the inability to serve the summons to him. All right. So let's actually talk about let's talk about the actual legal analysis, right? Why does Chief Justice Tawney conclude that President Lincoln lacked the power to suspend the writ of habeas corpus unilaterally? What argument does Tawney use? Okay.
He takes the legislative power.
Ah, why is this a legislative power?
Because it's concerning a war.
No, one at a time. Let her finish. How do we know that this is a legislative power?
I was going to say it's because it's concerning a war.
Well, where does the Constitution reference habeas corpus? Let's start there. Let her finish.
Article 2?
Is it? You guessing?
Article 1 or 2?
Yes, is there an answer? Sarosh?
Article 1, Section 9, Paragraph 2.
Okay, very good. It says, the privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. So this text tells us a couple of things. So first of all, we have this thing called the writ of habeas corpus. This was a tradition in the English legal system where a prisoner could challenge his captivity. Now, the writ doesn't necessarily mean the prisoner gets out. It merely means the government has to come forward and produce the body, so to speak, to explain, here's why we're holding John Smith. Also, producing the body means the guy's still alive, right? It's a check on whether he's dead or not. You can imagine a prisoner's dead, right? It's like, we can't produce the body. Okay, then why'd you kill him? Why'd he die? Think of like, here's the Count of Monte Cristo. They sort of lock him up on the islands, right? The prison. But we know that this habeas corpus writ exists, whatever that is. And it can be suspended. When? In cases of rebellion or invasion, and public safety may require it. Sarosh, was the United States in a case of rebellion at this time?
Yes.
It sure as hell was, right? The southern states were in rebellion. There's no doubt about that. So then what's the argument? Right? Why is Lincoln wrong?
So, what I read in this was what Chief Justice Tawney was saying was, you're right that somebody in the federal government has this right of suspending habeas corpus. It's not the executive branch. It's the legislature.
But how do you know this? I'll come back to...
Because Article 1, Section 2, or Article 1 is about...
So what? Says who? Why is that?
It's one of the enumerated powers of Congress?
Does it say that Congress has the power to suspend habeas corpus?
No, not directly. I would have to...
It does. It's right on the screen. Look, it's right there.
Probably if it's actually-
Does not say Congress. Does not. So Faven, let me come back to you for a minute, right? Okay, this is your point before. You're Abraham Lincoln's lawyer. You realize Congress is out of session and you're in a frickin' situation with rebellion and you can't wait for Congress to get back. President Lincoln asks you, can you make me an argument that I can do it under Article 1, Section 9? What do you say to him? You're Lincoln's lawyer.
I guess you can argue under. You could argue because it's in the time of rebellion, but it's a.
But what? Does it say only Congress can exercise this power?
It doesn't say only Congress.
So what if I make the argument, you're Lincoln's lawyer, say, Mr. President, I think it's ambiguous. I think the framers left it open-ended. And in that ambiguity, I think you can go do it. Would that be bad legal advice?
Well, since it's not specified, then no. I guess you could say it's an implied power.
Oh, so maybe the president who has the power to faithfully execute the laws, and maybe one of those laws is suspending habeas corpus. Again, it's not nuts, right? I think Tawney has a stronger structural argument. I think he does. But you sort of suggested these structural arguments are maybe more malleable, right? Applied, right? I think manipulate, that's the word you use, manipulate, right? Yeah, listen, right? So maybe Lincoln's not insane, right? He was a smart lawyer and he talked to his attorney. He said, look, guys, the Constitution's silent on this, okay? Yeah, you have the structural argument, but it says nothing about who suspends it, right? It says shall not be suspended. It doesn't say who suspends it. Why can't I do it?
And obviously, what would make, I guess, in this scenario, what would make it more appealing because of the timeliness of it.
Yeah,
the severity
we're in a
of the
pinch.
crimes.
We're in a pinch. We're in a pinch. Yeah, Sarosh.
My issue comes with this is when I'm looking at the natural reading of the Constitution, where
The natural reading, what's that?
well, the way it's supposed to be flowing. So Article 1 is talking about legislative power, if I'm not mistaken.
You're right.
We haven't even gotten to the presidents, so how can the president even
Yeah,
talk
but
about
how do we know what the natural reading of the Constitution is? Maybe the framers just put this there because it fit. Maybe it's a power that can be exercised by both branches.
Wouldn't they make it more explicit?
Maybe they forgot. Maybe they didn't think. I mean, again, do you demand a level of precision, or can you simply argue that it's an open-ended question? It's not clear. In other words, if the Constitution doesn't specifically say, thou shalt not do X, and it leaves the issue ambiguous. See, Faven? Yeah.
I'm telling you, I'm trying to like.
I see. I can see what's going on. Yeah, I can see it.
But then I start thinking about, okay, but what about the strict scrutiny and then this?
We'll get there. We'll get there. We'll get there. We'll get there. This is actually easier than scrutiny because this is straight up constitutional law. There's no test here. This is who can do it, A or B, Congress or the president, right?
Okay.
Tyler, your hand was up a minute ago. I didn't want to skip over, but I'll come back to you.
Yeah, okay. Your non-delegation doctrine, was that a thought at this time?
There's no statute, right? It's not like Congress enacted a statute that delegated authority to the president. This is purely a question of constitutional law. Who has the power? It's not about delegation. It's a hard. Now, again, I think as an objective matter, as a neutral matter, right? Tawney has a better argument. I agree with the structural idea that those powers listed in Article 1 are for Congress, and those powers listed in Article 2 are for the president. But I do not assert that I'm right, 100%. Right? It's not for certain, which is why having, I think, a structural principle of enumerated powers is one way to resolve it, right? You're a judge. You can say, well, how to resolve this? Well, here's one way, the text of Article 1, Article 2. But, I think you said the natural way of reading the Constitution says who, right? Says who? I don't know who says that. Now, there's also the argument of whether presidents in the past have used the suspension power. And I think there's some doubt of whether Jefferson actually suspended habeas corpus. I don't think he actually did. But we'll pretend maybe for a minute that he did. If past presidents had done it, that might bolster Lincoln's cases. And if past presidents have not done it, that might weaken Lincoln's case. This is what Justice Frankfurter calls in Youngstown a gloss on constitutional practice, that you're actually using constitutional practice to build what the Constitution should say. Everyone with me? All right, so are there any questions on the actual analysis? This is probably one of the easiest constitutional questions we have all semester, right? Who has the power, Congress or the president? This is a piece of freaking cake, right? Youngstown involves statutes, which is a lot harder. This is not about statutes, only about constitutional clauses. Maybe Barron is the easiest other case. I think this one's actually easier than Barron. I can teach the rule in one sentence. Article 1 is Congress, Article 2 is President. All right, everyone okay with the facts? Now, Lindsay, what happens after the case is decided? Things get kind of weird.
In Merriman,
Yeah, after Tawny made his decision, what did he do?
he sent
Yeah.
his opinion to the president.
What the hell is that about? Have you ever heard of such a thing before? In any of your cases, any law school courses?
No.
No.
And I guess I have a question now.
Please.
This isn't a Supreme Court
No, it's not.
case.
No, it's not.
So if he just sent this opinion to the president,
Yep.
and I understand we're learning this case in class today.
Yep, we are. I hope so.
But does this actually stand for anything? I mean, does what we get out of this case actually?
Is it law you should cite?
Well, I mean, I guess.
What is it?
Yeah. It's,
What is it? Yeah, Sarosh, I don't think.
My question would be, is it even a case?
is it binding? I mean,
This case is such a riddle to law professors. Now, again, I encourage you to read the Tillman article because I think it's very good. But the reason why this case is usually taught is for one of two reasons, right? The first reason is to assert that that President Lincoln ignored the Supreme Court, right? I can't tell you how many law professors are very smart who say that Lincoln ignored the Supreme Court. I can go to Tillman's article. He has a footnote, like takes up the entire page. That's his thing. He likes footnotes, take up the entire page. And they say that as a reason why that presidents should be able to ignore courts. Like Lincoln ignored the court, why can't other presidents? Okay. Other people cite this of saying that the president has these broad powers, right, which he should be able to exercise. Basically saying that Lincoln was right, that he should be able to suspend habeas corpus. The case itself is, again, very strange. It doesn't actually resolve much. I think it reaches the right result. To this day, the president has not tried to suspend habeas corpus. Again, it's only for Congress to do. So what does it actually stand for? I don't know. All right. Okay. So, yeah, it's a weird opinion. And eventually Congress went back and actually what's called ratified Lincoln's actions. They basically said, we approve the suspension of all acts the president took as if we had approved them at the time. So in other words, Congress said, whatever Lincoln did, we're okay with, and pretend we actually approved the suspension of the writ at the time Lincoln did it, which would then, I don't know, would then legalize Merriman's detention? It's even a hard question, right? Can Congress retroactively authorize the suspension of the writ? These are things that were never litigated. But Lincoln tried, or the Congress tried to basically bootstrap, so to speak, or make retroactive Lincoln's actions as legal. Yeah, Audrey?
So during this time, it was okay for Lincoln to do it, but today it would not be. 'Cause
Well, again, if it was okay because the Congress perhaps retroactively approved it.
Yeah.
Congress has not suspended habeas corpus in some time. Even during the Guantanamo era, Congress did not suspend the writ of habeas corpus. The reason why Guantanamo Bay was chosen was because it was outside the territorial sovereignty of the United States and was not subject to the habeas corpus writ. But then Justice Kennedy found that it was because Guantanamo Bay was under sovereign control. And it's a long opinion called Boumediene, which I'm not making you read. Long opinion. You can read it if you like. Okay. All right, other questions on Merriman? It's a bizarre case. I'm with you, Lindsay. It's every time I teach, like, what the hell am I reading? Right? What is this? Right? What is it? And I don't quite know. Yes, Sarosh.
If I'm not wrong, according to Professor Tillman, because this is technically not an order, the president never ignored.
You can't ignore an order that doesn't exist. There was no order to Lincoln at all. It was a contempt citation against the general. There was nothing for Lincoln to ignore.
Was
And-
that basically his suggestion that maybe he should take up this, like, do something about it? That was a reading I got out of it, was like, hey, maybe you should look into the general.
Yeah, feel guilty about it, maybe reconsider it. It was basically an act of persuasion, right? I mean, it's basically like a subtweet. You're basically complaining that your subordinate broke the law. Wink, wink, nod, nod. Do something about it, Mr. President. There's not much evidence that Lincoln ever really cared much for the decision because it wasn't against him. It was like, all right, whatever. I mean, if you think about it, it's in one regard similar to Marbury, where at the end of the case, Marshall did not order the delivery of the commission to Marbury. So Jefferson's like, all right, what do I do with this? I don't know. I'm going to ignore it because there's nothing for me. In other words, Jefferson couldn't ignore Marshall because Marshall didn't order Jefferson to do anything. Lincoln didn't ignore Tawney because Tawney didn't order Lincoln to do anything. They're the parallel in that respect. Okay. All right. Other questions? All right. Let's do another Civil War issue, which is the emancipation. And let me take a step back. Dred Scott, which we'll study, I think, is it next week? I think next week, was a very significant case in this time period. And Lincoln argued vigorously that because Dred Scott only concerned the Dred Scott and Sanford, two individuals, the U.S. government was not bound by the case. Indeed, there was a question of whether the government could grant citizenship to former slaves who joined the Union, right? So imagine you joined the Union Army and you were a former slave. Can the government grant you citizenship? Under the holding in Dred Scott, the answer was no. Dred Scott held that people of African descent could never become citizens no matter what. But Lincoln's Attorney General says, we'll tell you what, if these individuals join the Union Army, we will grant them citizenship, which was a huge, huge thing. So in that regard, Lincoln effectively said, I'm not bound by Dred Scott, and I'm going to take a constitutional action directly at odds with Dred Scott. Right? So now we have the Emancipation Proclamation, which was a significant constitutional act that was very controversial. So Chelsea, walk me through at a high level what did the Emancipation do?
Basically freed slaves from the rebel territories.
And not all rebel territories, certain rebel territories. For example, like it's random, like in Louisiana, like certain parishes were actually supporting the Union, so those were in, I think New Orleans might have been part of it, but they weren't part of it. Okay, so they basically freed the slaves in rebel territories.
Yes, and then they joined the Union.
They had the option.
Yeah, the
Yeah.
option. And it basically made the rebel states that they did allow free not be able to continue with the Civil War.
Okay, very good. Thank you. Thank you so much, Chelsea. The Emancipation Proclamation emancipated or freed slaves in almost all the rebel territory. Not all, but almost all. It did not emancipate the slaves in the Union states. For example, Delaware, Kentucky, Maryland, those were border states which had slavery, and Lincoln did not touch those provinces. Right? So Audrey, what authority did Lincoln have to emancipate the slaves?
He used his authority under Article 2, Section 2.
Okay, and what does that say?
It says, well, he uses that he's the commander-in-chief
Okay.
portion of it.
And does that say that he can emancipate slaves?
No, it does not.
So where does the power to emancipate slaves come from?
He used it as a war measure and
It's a
said
war measure.
that as commander-in-chief, this is a military necessity in order to preserve the Union.
And what exactly did he do?
He wrote this, or made this speech, the proclamation, because the proclamation is kind of like an implied power of
Yeah, we got these implied powers again. We usually say unenumerated powers, but it's the same thing as implied. Right? So here's what Lincoln basically said. He argued that, let's say it like this, right? Anyone ever see Gone with the Wind, the movie? Do you remember the scene in Gone with the Wind where basically the Union troops come through and they seize all the cannons and they seize all the warehouses and the homes? It's a general notion that during a time of war, that the conquering army can seize munitions, right, cannons, railroad tracks, warehouses, factories of the conquered, right? When the Union seizes some territory, they can then take the property in that area, the personal property, right? The things. The premise of Lincoln's Emancipation Proclamation was based on that power. Here, in a bizarre twist, he relies on Dred Scott. He effectively says that the slaves under Dred Scott are property, are chattel. And as chattel, I am seizing these people in the same fashion that I would seize a cannon or a railroad. And once the property was seized in the hands of the Union government, he then released them and emancipated them. This was, again, Merriman, I think, was a fairly easy case for Lincoln to make an argument. Oh yeah, sure, I can do this. But the emancipation was a heck of a lot tougher, and it was very controversial. Justice Curtis, right, Benjamin Curtis, he resigned from the Supreme Court after Dred Scott was decided. He was so disgusted by Roger Taney that he resigned from the U.S. Supreme Court. I think the only time it's ever happened. I'm sure O'Connor came close after Scalia, but it was the only time this ever actually happened. And Justice Curtis wrote an objection, arguing that even though I think this is the correct moral judgment, that the president doesn't have this power, right? And the president can't have this implied constitutional right. But the government of the executive branch doesn't have this authority. So this was a very controversial action where Lincoln relied on really no text at all, right? At least with habeas corpus, it's kind of ambiguous of who can seize property. But here he relies on Dred Scott to assert that these people are chattel. And as chattel, we can seize them. And as property that's seized, we can then release them as free. It's a bizarre argument, isn't it? It's very like, whenever I teach this case, people get like this sort of like dirty feeling, right? It's like, wow, I thought this Emancipation Proclamation was this awesome thing, and wait a minute, that's not so. Wait a minute. And again, Lincoln didn't just say, you know what, slavery is immoral, I'm ending it today. He didn't do that. He made an argument based on Dred Scott. He made an argument based on law. He was a lawyer. He didn't just go out and say, you know what, screw this southern states, you guys lost, give up your slaves, let them go free. He didn't say that. He made a legal argument which then was criticized by his contemporaries, saying, Lincoln, this is nuts, right? Even abolitionists like Curtis said, Lincoln, this is too far. This is way too far. And let me give you one other fact that came up later. When the government seizes property, we've talked about this already, that's provide just compensation, right? A lot of the former plantation owners sued the U.S. government for a taking. That Lincoln's emancipation took their property without just compensation. So by Lincoln using sort of legalistic argument, he basically opened up the door to takings lawsuit against the U.S. government. Now take a look at Section 4 of the 14th Amendment, which no one ever reads, but it's there. All right, Section 4 says, neither the United States nor any state shall pay any debt for the loss of emancipation of any slave. The United States shall not pay any debt or claim for the loss or emancipation of any slave. What is that provision getting at? This was saying that Lincoln's takings will not result in compensation. Isn't this bizarre? The 14th Amendment, which was designed to ensure equality nationwide, recognized that Lincoln probably screwed up and took property without compensation. So this is effectively saying, Emancipation Proclamation, we're not gonna pay for that. Sorry, you can't. And because it's in the Constitution, it's supreme law of the land, we're not gonna pay you any money. I've actually seen estimates of the. It's ghastly, but there were dollar amounts, right? People knew how much they were suing for, and this was designed to prevent states from suing and slave owners from suing. It's a bizarre. Again, the Civil War was a period of such turmoil, but also significant constitutional arguments that were being made by those who were in power. And they tried to use the law in ways that don't fit with what we're taught in high school, right? They don't fit with what you're taught in on 4th of July. Everything is a little bit different. Yeah?
I was saying it's almost watered down.
Oh boy, yeah. Yeah.
I was gonna, my thought is, when you really, like with Lincoln making this legal argument, it's almost like the law is dehumanizing almost. I mean, when you start talking about, we're gonna say people are property to go like this back, I mean, there was another, and I can't remember which one it was, there was another case we went over the other day that it just seemed like the law can be really dehumanizing.
I'm sorry, Heart of Atlanta with the commerce, with the people moving from hotels,
I mean, that's what it feels like to me, is like, when you make not you, but like when people make these arguments, it's almost like we're trying to do this for moral reasons, but at the same time we're going to dehumanize people to get around. I mean, it just.
Well, we'll do Dred Scott, I think, is it next week, I think? I think it's next week. Usually it's class 14 or 15, I think it's next week. Or actually, I can't keep track. This class moves so quickly, I can never remember where the hell we are.
It's, class 12.
Okay. Thank you. Thank you, Sarosh. Yeah, so it's on sorry, Monday the 17th. So 1 week from yesterday. I mean, this is a hard class for a lot of reasons, but I think that's one of the most jarring things which students raise to me year after year. Where often the courts and Congress and the president approach things in certain ways that dehumanize. I think that's an absolutely valid point. I think it's a fair point.
I guess it's because, like you said, you're taught one thing in high school when you take history. Then you get into college and undergrad, and they broaden it a little more, but they don't tell you.
They don't know.
Stuff.
They don't know. Most people don't know this stuff.
I mean, it's
they don't know this stuff.
It's interesting to see how the law can be applied in a way that it's not. I don't want to say without any regard for humans, because I mean, his end goal was.
That's right. And that's the part that I think gives students the most anxiety, right, or the most difficulty, is that Lincoln was ultimately pursuing a goal that's inherently moral and just and right. And he used arguments to get there that are entirely amoral. Last semester I gave a midterm, or it was a final exam on the Civil War, and some legal bloggers found it and they sort of flipped out. And if you just look at these sorts of questions in the abstract, it looks pretty evil what I'm asking about. But when you actually look at what Lincoln did, these are significant constitutional questions that were addressed. My final last term was the impeachment of Abraham Lincoln. And one of the questions actually asked, could he have been impeached? The question was, he survived the assassination, right? So let's say he survived the assassination. And the question was, could he have been impeached for the Emancipation Proclamation, for violating Dred Scott, right? That basically the president disregarded provisions of Dred Scott, and could he be impeached for that? I think it's a tough question, because a lot of people at the time, like Benjamin Curtis, thought he was breaking the law. Yeah, and the irony is the book called "The Impeachment of the President Lincoln" was actually authored by a prominent African American professor at Yale, Stephen Carter. Really good book. I encourage you to read it. Called "The Impeachment of Abraham Lincoln." It's like historical fiction where it's like accurate, kinda, where they take real life events and they sort of twist it around, but it's an excellent book. And the premise of the book was this, is that after the Civil War ended, the people were mad at Lincoln because he wasn't doing enough to push forward Reconstruction. And they actually were impeaching him for not being aggressive enough. So it's like the exact opposite of what you would think. Anyway, I thought it was an excellent book. I read it a couple of years ago and I made it my exam topic last term.
That's how I first knew who you were.
Oh, God. Oy vey.
Yeah, it was on like Above the Law.
Yeah.
And I was like, oh wow, and then I found out that I had you for constitutional, and I was like, oh my goodness, it's final. So.
It's not that bad. My point is, you're well prepared for it because we talk about these issues for an hour or two at a time. So there's no surprises. But I think, Lindsay, you make a fair point. There's a dehumanizing aspect to the cases. And when you get to Dred Scott, it's going to be bad. When you get to Korematsu for tomorrow and detention, it's bad. We'll do a case involving eugenics, where the government sterilizes a woman. Students tell me they start crying when they read that. It's bad. Yeah, there's bad stuff in this class. I don't sugarcoat it for you. Not one grain.
I guess it's just a little shocking coming into law school and then realizing that the law is the way it is, and it affects people. I don't know. It's weird.
No, again, I don't expect you to like it or to agree with it or even want to promote it. My concern is, do you speak it? Can you use these arguments perhaps to argue to the contrary, right? Let me put it this way, right? Pointing out the egregious reasoning in Dred Scott, for example, or Korematsu, can then help you in a subsequent case like the travel ban litigation, right? Using this sort of moral arguments does have resonance when you back that morality up with legal principles, right? You can't just go to court and say, this is not fair, let my guy win, right? Let my guy out of jail, right? You're not going anywhere. So you have to have the legal structure, Randy says language of the law, I like that phrase, the language of the law to back up whatever moral sentiments you use.
I think whenever you said eugenics, that reminded me, I think just now Clarence Thomas used it as a kind of an abortion argument as eugenics, which I didn't know that was the case that we're reading.
It was a dissent from it wasn't even dissent, it was a statement where Justice Thomas ties, just be careful, where he ties the history of the abortion movement to eugenics, and maybe I'll come back to that when we do abortion. I'll give this one bit. In Roe v. Wade, there's a line where Justice Black, no relation, wrote the majority opinion. He's talking about why abortion is such a contentious issue, and he references overpopulation. Now, why would a justice writing about abortion talk about overpopulation? In the 70s was a fear that we would run out of natural resources and their population was growing too big, and perhaps one way to cull the population and reduce our strain in the environment is through abortion. He put that line in there, right? It's in there. You can go read it. It's in your casebook, right? He references overpopulation. Why would you talk about overpopulation in an abortion case, right? He's worried about the limits of growth, which was a prominent book in the 70s. A population bomb was another one. Yeah, we'll get there in about 2 weeks. Yeah. All right. Any more questions on the emancipation? We'll go on to the seal seizure case, a little bit less dicey. Anyway. Yeah. I swear, when you have this thing 4 nights a week, it feels like more intense. Like you don't have like a period to breathe after I'm done. It's like next. Tomorrow we're doing Watergate, so we're jumping right. Is Watergate tomorrow? I think it is. Yeah, Morrison v. Olson. I think it's tomorrow. This class moves so quickly. I never remember where we are.
That's on Thursday.
Okay, so tomorrow. Oh, we're doing Korematsu tomorrow and Watergate on Thursday. Thank you, sir. Okay. Okie dokes. All right. Any other questions on emancipation or Lincoln? We'll come back to this when we do Dred Scott again. We'll do a lot more on Lincoln. He was a president for a fairly short period, but so much happened during his administration between when he was elected in 1860 and his assassination some years later. 1865, I think he was assassinated. So basically 5 years. He had more in 5 years than most presidents will in a lifetime. There's a reason why he went gray that quickly, right? He just, if you look at his pictures at the start, of the Civil War, he looks like he aged 20 years. All right, let's do the still seizure case. Who's next? I lost memory. Okay, sorry here. I really don't remember. Okay. All right, let me give background. I'll come to you in a second, Lindsay. Following the end of World War II, the big nations of the world formed a group, an organization called the United Nations. And the purpose of the United Nations was to have this international body that could help resolve disputes without engaging in military action. And the idea was that if countries came together and had this diplomatic forum, that it would reduce the need for these sorts of bloody world wars that we saw during the 1930s and 40s. The United States joined the United Nations by virtue of a treaty that was approved by the Senate. Okay. Some years later, a conflict arose on the Korean Peninsula. Today we have a North Korea, and we have a South Korea, right? Why do we have two Koreas? Because of the Korean War. It's often called the Korean conflict. It's hard to summarize exactly why it began. In fact, the reasons aren't very important. But what you should know is that there were two regions. The northern part was backed by the Soviets, right, the Soviet Union. And the southern part of the country was backed by the Western world, the United States and most of Europe, right? This was largely a war fought between communist and non-communist nations, but it was taken out on the people in Korea. And to this day, the nations are divided, and we have those nuclear test missiles, Rocket Man, all this stuff, right? Beautiful letters, as we say. During the Korean War, there was no declaration. Congress never declared war on Korea. Instead, President Truman relied on the UN treaty, which we ratified, as his authority, because the UN basically said we can engage in military action in Korea. There was a very strong question whether the Korean War was even lawful, right? Would the courts intervene and tell the president, you can't engage in this war? No, they did not do that. But the legality of the Korean conflict came to the court in a different vehicle. And it came in the context of this so-called steel seizure case. All right, so Lindsay, you want to give me the facts, please, in Youngstown, Sheet and Tube Company versus Sawyer?
So the Korean War was going on, and the United States was going through a labor crisis.
Yeah.
And the steel workers were talking about going on a nationwide strike.
Mm-hmm.
So the day before they went on the strike, President Truman ordered for the government to take possession of the nation's steel mills.
Lindsay, let me ask you a question. What is an executive order? What is an executive order?
An order given to the executive
Smart aleck.
for people to do something?
Okay. What authority gives the president the ability to issue an executive order?
Article 2.
I like what you're thinking. Is there an executive order clause in the Constitution? No. Okay. An executive order is nothing special, right? The president could go out on the balcony and announce, hey, you go do this, right? That's an executive order. The president can write a tweet, as he does, and issue orders to subordinates, and that's an executive order. The president can write out on a piece of paper. He can type it. He can whatever he wants, right? The executive order is merely the president giving instructions. And the take care clause of the Constitution, I think that was what you were getting at, which says the president shall take care of the laws be faithfully executed, means the president can supervise his subordinates and tell them what to do. The president can't do everything himself. He's only one person. He has an entire administration, people who are hired to do his bidding, right? And here the president issues an executive order, Executive Order 10340, in which he tells the Secretary of Commerce, Sawyer, if a strike occurs, you are to take ownership of the steel mills. And by the way, the employees of the steel mills have to go to work. The managers have to keep managing. The accountants have to keep making payroll, right? In other words, the mill has to keep going as if nothing happened. Of course, what happens if you ignore the order? Well, usually, if you have a job and you skip work, maybe you'll get fired, maybe you'll get fined, maybe you'll get dock pay. Here, you're probably arrested, right? If you were a manager supervising the steel mills and you failed to keep it operational, they'd probably lock you up. So this was not a joke, right? This was an actual military takeover, the kind of thing we think about in like Latin America, where they basically take over and nationalize an industry. Now, this wasn't permanent, but there's also no end in sight. Chelsea, let's talk for a minute. What did Congress think about this steel seizure?
Like the whole thing?
No, that's not the case, but of Truman's actual decision to seize the mills. What did Congress think about this decision, this executive order?
That he was allowed to do it because it was necessary.
Congress.
Oh,
What did Congress think about this entire situation?
I'm sorry, I missed it.
Audrey?
I think they rejected the use of the seizure.
Well, I'm not talking about what happened before the executive order. After Truman signed the executive order, what was Congress's reaction to this?
They drafted wait, am I on the right track?
No.
Okay, never mind.
Tyler, what was Congress's reaction?
They didn't answer.
They didn't do a damn thing. Yeah.
Truman said, if you want to reject this course of action, that I followed, let me know, and they didn't
Very good.
respond.
Very good. Yeah. Congress didn't do a damn thing, right? The president issued this order. He nationalized the steel mills, and Truman was like, "Hey, Congress, if you want to, reject my action, you can do this." But the president didn't ask for permission. This is like the expression, it's easier to ask for forgiveness than for permission, right? You all know that one, right? Truman never asked for permission. He said, all right, if you screwed up, you can tell me. This is, I think, significant because if Congress is not willing to safeguard its legislative powers, why should the court? In other words, if Congress is not willing to tell the president, no, you can't do that, that's our job, then why should the courts intervene? I think the answer to that question is one branch of government can't relinquish their own power. Even if you have, for example, Congress that's willing to be very friendly to the president now, a Congress in the future may not be so friendly. And one Congress can't surrender its own authority going forward. I think that's an important principle of law that's embedded in the opinion. All right, so Truman sent these messages to Congress. Congress doesn't do a damn thing. Instead, the mill owners run to court. And the timeline is just as insane. Within 30 minutes of the seizure, the mill owner challenges the executive order. And a couple of weeks later, a district court halts it. Right? Imagine you're that district court judge who tells President Truman, in the middle of a war, you can't seize this mill. At that point, there was a race to the Supreme Court, and the case was basically argued, decided to have 2 months. Right? I mean, this was a fast process. There's a consequence, though, when you decide a case so quickly. Get fractured. There were 6 separate opinions, right? There were 6 opinions in the majority, right? Everyone wrote their own opinion. This is like seriatim again. This is like in Chisholm, right? What the hell's the holding? Well, Justice Black had the majority opinion. That much is easy. But there were 6 separate opinions in the majority. And they each had, I think, different and maybe even inconsistent approaches to the law. And then you have a single dissent from Chief Justice Vinson. Let's walk through them one at a time. So Fabian, let's talk about Justice Hugo Black. What's Justice Hugo Black's approach to this case?
So he made a textual argument, and pretty much he said since the president didn't have any unenumerated power.
Very good. Yeah.
That he could only seize if the Constitution or Congress authorized, and that didn't happen. So.
Very good. Very good. So Black was a textualist. What does that mean? He wasn't interested in some sort of implied or any enumerated powers. He said, look at the Constitution. The president only has the power to act where there is express or implicit authorization by the text of the Constitution. He looks at the vesting clause, for example, right? The executive power shall be vested in the president. Black says the executive power does not include the power to seize property. How does he know that? How is he so sure? The dissent seems to think it does. Is he right or wrong? The commander-in-chief clause, right? Here I think it's a little bit stronger. There was no declared war, and this was on the home front, not abroad. Generally, the commander-in-chief clause concerns foreign affairs, fighting a war on some other battleground, not on the home front. And there was no invasion as well. And he talks about the take care clause. What Black basically says is the power to execute the laws is an executive power. That is, you execute the laws Congress enacted. The decision to take the property was a legislative act, and a legislative act cannot be an executive act. Therefore, it's not a faithful execution of the laws. Therefore, the president had lacked the constitutional and statutory authority to act. And there's a violation of the separation of powers. Any questions on Justice Hugo Black? Okay, Sarosh, let's talk about Frankfurter for a minute. Frankfurter, I think, had, well, Jackson's probably the most influential, but I think Frankfurter had the one that judges actually rely on the most. I think most judges cite Jackson than they do Frankfurter. You'll see that in the reading whenever the class that we do Noel Canning, it's later this week. So let's talk about Frankfurter for a minute.
So, from my reading of this, I got that Justice Frankfurter was basically talking about how it almost seems like he's saying that President Trump has been a little too dictatorial with what powers he's allowed to have.
Yeah.
And he basically makes a connection to like talking about Hitler and
Who he does.
Mussolini and Franco.
Yeah.
And basically, he says that the framers of the Constitution were not looking for a dictator to come and seize. I think he talked about the Mississippi Rebellion there.
Yeah, very good, very good. Keep in mind when this case was decided, right? This was decided shortly after World War II. And the justices had just lived through fascism on the European continent, Nazism. And I think at least the judges in the majority were concerned about having an overreaching executive. Right? Hitler was elected, and then he started to amass all these powers, which the legislature willingly gave up. Justice Jackson had this one line at the end where he said, Congress may give up, but the courts will not. Right? The courts will be the last line of defense to give up that authority. And I mean, Justice Jackson believed that firmly. In fact, Justice Jackson, I'll only take a detour to him, he was the lead prosecutor at Nuremberg. Right? After World War II concluded, there were trials for the war criminals, the Nazis. And Justice Jackson took a sabbatical from the Supreme Court to prosecute the Nazis at Nuremberg. He saw firsthand what happens when the legal process fails to constrain an overreaching executive, Hitler, the chancellor. So I think both Brother Frankfurter was Jewish as well, and Jackson got this point very well, and they were worried about what would happen. Frankfurter also makes a point, Lindsay, about what he calls historical gloss. What's he getting? I think this is a concept that will come up a lot in this course.
That the historical past practices of the past presidents add a layer to the Constitution.
Yeah, very good. What do you mean a layer? Let's give me just a little bit more.
You can't rely on, he says you can't just look at the text of the Constitution to determine the meaning of executive power, but that the president's actions before, there was no systematic, you look at what the presidents before did to see what the real powers are, because if the presidents before had done it systematically, then it's probably one of the executive powers that's in that gloss over the Constitution.
Right. Here, Frankfurter is not actually interpreting the text of the Constitution itself. What he argues is that there's some sort of long-standing practice that was not challenged by the other branches. That's important. If there's some sort of disputed practice where the parties, the branches disagree about it, that doesn't count. But if the president has been doing something for a long time, and Congress has not argued about it, right? At that point, the courts can presume that this should be part of the executive power. Right? The idea is a gloss or a layer, so to speak, was added to the Constitution itself. And this now gives rise to, no, you didn't take improper two yet. Justice Scalia jokes and he derides this. He says, well, that means if the president breaks the law for 200 years, that means he can keep breaking the law, right? In other words, think of like your little kid. If you let a kid keep stealing cookies from the cookie jar, at some point, that means the kid can take a cookie from the jar, right? That's the new rule. So there's a problem with a Frankfurter reading that it basically rewards wrongdoing. But the flip side is, who's to say it's wrong if Congress is okay with it, right? If Congress is not willing to enforce their prerogative, then why should the court step in to tell the president not to act? In other words, if you as a mom or dad are not willing to tell your kid to stop eating cookies, then why should someone else say something? If that's what you're okay with, that's a new legal situation. But here, there's no history of presidents seizing private property, which is probably not true. And I think the dissent points that out. Lincoln, for one, seized the railroads. That was my final exam last year, right? One of the articles of impeachment against Lincoln was that he seized the railroads and the telegraph wires. So it's not even clear Frankfurter's right. Now, there might have been isolated instances where presidents seized property, but it wasn't a systematic process. All right, let me lecture a bit because we're running a little bit short on time. But Justice Douglas makes, I think, a very good textual argument based on the structure of the Constitution. A taking requires compensation, right? Compensation is paid from the Congress. Congress appropriates money. Therefore, the president can't pay compensation. Therefore, the president can't seize property. If that's right, then Lincoln was wrong. If that's right, then Lincoln did not have the power to seize an Emancipation Proclamation because he didn't have the power to pay the compensation in the first place. Indeed, there was no compensation. He simply took it without compensation at all. Right? If Justice Douglas is right, then the Emancipation Proclamation is unconstitutional. That was on the exam too. That was one of the wrinkles. But I want to focus most on Justice Jackson. Jackson's opinion is considered not quite the majority, but the most influential opinion. And most of the justices have said over and over again that they look to Justice Jackson. Justice Jackson was a lawyer in the Roosevelt administration. He was the Attorney General. He was also the Solicitor General. And Roosevelt engaged in some pretty broad exercises of executive power. And as a government lawyer, Jackson said they were okay. And sort of like Chase, he had second thoughts when he got into court. And at one point, he basically criticizes the things he'd written about in the past. He says, well, those things from the Roosevelt administration, those were, maybe I learned differently. And what he says is, when you have these tough executive power questions, there are not any clear guidelines. Isolated clauses of the Constitution can't resolve these problems, right? There's a poverty of resources, of authority to resolve concrete problems. So instead, he constructs this sort of framework, right, which law students love, and they always apply completely wrong. So let me make this very clear for your notes. You're only going to be talking about Justice Jackson's frameworks when you're discussing executive power, right? Does the president have the power to take a certain action, right? I can't tell you how many students screw up the exam, and they say, the question is, does Congress have this power? Say, no, it's in the first zone. And they're not, no, that's wrong. You only talk about Youngstown and Jackson when they're talking about executive power. Let me get the diagram. I love how this diagram looks in here. This video is one of our better ones, by the way. If you want to watch the video, this one you should probably watch. But Jackson articulates that there are three zones, or tiers as they're sometimes called, of authority. And the courts have to scrutinize where is authority coming from. So let's take the first zone, which is the easiest one, right? In the first zone, the president can rely on his own constitutional authority. That is Article 2. Article 2 gives him the power to commander-in-chief and certain things like this, right? If Article 2 gives you some power, the president's in good shape. But you also have authority from Congress. This is a question of delegation. If Congress passes a statute saying that the president can seize the steel mills, and the president may have some sort of Article 2 power to do this, then he's in good shape. If 2 of the 3 branches agree the president can do something, his authority is at a maximum, right? He has a maximum authority. As a result, the courts apply what's called a presumption of constitutionality, right? Where the courts presume it's constitutional. And it's a good presumption because the president and Congress are both on the same page. Now here's the difficulty. If Congress gave the president the power to do this, it's not going to be in court, right? If Congress passed a statute saying you can do this, it's an easy case. Who even cares about anything else? So this entire framework doesn't really help you with much. People love it, except when you actually think about it for more than 3 seconds, right? If Congress says you can take the mills, then what the hell are we doing here? You can take the mills. Also, what are the president's executive powers? They're implied. They're unknown. Right? In the same breath that Jackson says we don't know what these powers are, he then makes these unenumerated powers essential to deciding where you are in the scope. Then you have this third tier, right, where he says your authority is the lowest ebb. Think of like, shallow water. Here, the president only has his Article 2 powers. He does not have Congress's Article 1 powers. In other words, he's acting based only on his own powers. This is where Jackson actually has some salience, right? If the president walks into court saying he only has constitutional authority, as Truman did, then the courts scrutinize it with caution, right? There's what might call strict scrutiny. The courts will strictly scrutinize whether the president actually has this power. Again, the case turns entirely on whether the president has the Article 1 powers, or the Article 2 powers. If he has the powers, he's good. If he's not, he doesn't. And then we have this third zone, right? This sort of zone of twilight, where it's not quite light, it's not quite day. You don't know what time it's like. Sort of the school. There's no windows inside the classrooms, right? It's always a zone of twilight. And here, Jackson's like, yeah, we don't really know. So frankly, this framework is not very helpful. In this case, Congress did not give the president the power to seize the mills. And Jackson says there's no inherent power to seize property. Therefore, he can't do it. But the framework students love doesn't really get you much. It doesn't. I used to like it a lot more than I do. Now I realize it kind of doesn't really get much. I go back and forth. You watch my old lecture, like Jackson. Now I'm like Frankfurter. I've become over Frankfurtarian over the years, I suppose. Frankfurter's law clerks called the hot dogs. Frankfurter. He had all these little hot dogs. Yeah. But this is the Jackson framework. It's important for you to know it because people often discuss it. But you have to consider the interaction of Congress and the president in these sorts of disputes. All right, so any questions on the Jackson concurrence? Again, very influential. Doesn't really help you much, but it's extremely influential. Okay. Let me do the dissent in a minute. Chief Justice Vinson wrote the dissent joined by 2 others. And he said that, contrary to Frankfurter, there was some other history. Washington, Jefferson, Lincoln, Roosevelt, right? Great presidents during times of war dealt with emergencies by acting promptly and resolutely to save federal programs, even when they lacked statutory authority. We discussed, for example, Jefferson acquired the Louisiana Purchase, right? There was no statute saying you could buy the property. He did it anyway, and Congress later approved it. Think of Lincoln with the Emancipation Proclamation. There was no statute. Think of the seizure of the suspension of habeas corpus. There was no statute. Congress approved it later. Right? All these instances where the president reacted to breaking emergencies, and they took decisive action, which Congress later approved. Right? Think of Hamilton with an energetic executive. The executive was designed to be vigorous, to respond to fast-moving events. Chief Justice Vinson said that President Truman could faithfully execute the laws by acting in an emergency to maintain the status quo, preventing the collapse of the programs, right? If Truman waited till Congress came back in session to pass some laws, the entire steel industry could have collapsed. And the war efforts in Korea could have been hampered, right? We wouldn't have enough metal for military equipment and stuff. Therefore, the president can take decisive action. But of course, this is the question that Jackson raised. If the president can take action in an emergency, what happens when the emergency doesn't end? And that fear, I think, pushed the majority over the edge to rule against President Truman. Minutes after Youngstown, Truman, in fact, ordered the steel mills to be shut down or returned to the owners. The labor strike occurred, lasted for 50 days. Wasn't that bad. The war continued. Okay. Questions on Youngstown? I know it went on quickly, but if you want to watch the video later, it'll probably help you a little bit more. This video should be in your notes loud and clear. But only apply it when we're talking about executive power. Don't give this to me in other contexts. It's every exam, like 3 or 4 students screw this up. It makes me very angry. Because it means they obviously took notes, but they didn't even know what they were writing down. They just wrote, oh, zone 1, 2, 3. Okay, I got it. They didn't even understand the context. All right. Questions on Youngstown? Question on emancipation? All right. Tomorrow we do Korematsu and the Japanese detention cases. Not easy reading either. I'll see you tomorrow. Thank you so much.